The Honorable Justices of the Montana Supreme Court. This court is now in session.
Good morning. Don't you think it's great how everybody just kind of pops up on the screen there one at a time? It's like, it's magical. It's magical. Here we are. Hopefully everybody's mics tuned in. We'll see, I guess. This is the time set for oral argument in cause number 190731, State of Montana versus Travis Staker. I see that we have counsel present. Are you ready to proceed?
I am, Your Honor.
Mr. Lubeck, go ahead.
May it please the court, my name is Mark Lubeck. I represent Travis Staker. We are asking the court to reverse the district court in this case and hold that Mr. Staker had a reasonable expectation of privacy in his text message communications with Lily, and that the remedy is suppression of all the evidence. Article 2, Section 10 of the Montana Constitution declares the right of individual privacy is essential to the well-being of a free society and shall not be infringed without a showing of a compelling state interest. In 1972, the delegates not only enshrined the right to privacy into the Constitution, they told us that it was necessary for a free Montana. And while the delegates couldn't have conceived of a day when cell phones and text messages would change human communication as they knew it, they were aware of the risk posed by the advancements of technology. This court, of course, addresses Article 2, Section 10 and 11 together and resolving search and seizure issues. And together they provide robust protections to the citizens of the state of Montana. The question in this case is whether electronic communication will be protected by our Constitution in the same manner as a spoken word. We argue that it does for three basic reasons. This court has stated and held that we have a reasonable expectation of privacy in oral communications with private citizens. That text messages are replacing oral communication and becoming a main mode of communication. And that we share incredibly private information via text messages. This court, of course, analyzes the CATS factors to determine whether a reasonable search and seizure has occurred, whether that person, in this case, Mr. Staker, had a reasonable expectation, or excuse me, an actual expectation of privacy, and whether society is willing to recognize that expectation of privacy is reasonable, and the nature of the state's intrusion. In Getz, Allen, and Stewart, this court held that the defendants had reasonable expectations of privacy in the oral communications that they had with private citizens, and that the government was not monitoring their conversations and electronically recording them. The agents in those cases acquired the defendants' verbalized thoughts through private citizens. This is distinguishing in this case, the factor is that Agent Noe was involved from start to finish. He is the only individual that monitored and recorded the conversations of Mr. Staker. The search in this case involved the inducement and subsequent recording of Mr. Staker's text messages. Mr. Staker had an actual expectation of privacy that he was communicating with Lily, not a government agent who was monitoring and recording his conversations. This court has stated that the touchstone of subjective expectations is not some physical location, but rather the individual's desire to keep some aspect of his or her life secure through the perception of the public. The focus of the inquiry should be on the degree of public exposure that occurs. In this case, Mr. Staker took steps to protect his privacy. First of all, he believed that he was engaging in a private conversation with Lily, a private citizen on his personal cell phone, and not a government agent. Two,
Mr. Lubeck, I want to ask you a question and cut to what I think is the heart of this, which is under the objective expectation of privacy. And I don't see how this is any different in essence and dynamic than if Mr. Staker had scratched out a written note, dropped it in the mail, and sent it off to Lily. He has no expectation of privacy that Lily is not a government agent. And I don't see how the government is monitoring anything here, because what's happened here in essence is when Mr. Staker scratches out this text message, he's making the record and then he's sending it to this other person who happens to be a government agent. So I don't understand how Getz and progeny even fit here. and how this is any different than that scenario.
Well, Your Honor, first of all, it kind of sounds like the analogy that is made by the state as to a letter. This court has never concluded that you lose privacy in a letter that is no longer in transit. That's Fourth Amendment law, certainly, and other state courts have held that. But as far as my research I've determined, I have not seen that this court has ever held that you do not have a reasonable expectation of privacy once a letter has been transmitted. I think that if there's government inducement and prompting, then in that scenario, you would need to have a warrant. So as to the
Counsel, could I ask a question on that?
Yes.
Underlying the whole case here, in my mind, is this issue of inducement by the government, which normally formulates in an entrapment defense. So I guess, could you kind of touch on the significance of the lack of transparency, or that the government was involved directly with a STAKER?
Sure, I think the inducement is critical to this. This is what makes it a state action. The state created an advertisement for the purposes of inducing individuals to make inquiries about prostitution. They knew that people would respond to it, and numerous people did. They did this intentionally to record those conversations. And that's what's so important here. Is that
All right, well, I'm sorry, could I direct your attention to 46-5-112 subsection 3. And if you want to address this in rebuttal, that's fine. But that is the statute pertaining to electronic surveillance. And it specifically allows the government to maintain the contents of information on its own devices. And I will also direct that to the state, that question as well.
Your Honor, may I have that statute?
46-5-112 subsection 3. And that speaks of the government, an individual acting in the capacity of the government or state agency, and that the information on that electronic device, it does not need to have a search warrant. So if you want to address that later, that's fine. I did get it from your briefs.
I will take a look at that. I'll take a stab at that. We're talking about the Article 2, Section 10 and 11. It's possible that statute could be unconstitutional as applied to private citizens. We still have to apply the two-part test, whether the person had a reasonable expectation of privacy and whether society would be willing to recognize that as reasonable. And I think based on the facts of this case and the case law, that statute could not possibly apply to Mr. Staker's situation.
So, Mr. Lubeck, it sounds to me like you're arguing the conversation by itself was an unreasonable search because it invaded his right to privacy. Is it your position that all undercover investigations would violate the right to privacy because the defendant didn't know that he was communicating with the law enforcement officer?
We are not making that specific argument. We are arguing that in this case that the government's inducement in recording of Mr. Staker's written thoughts was unlawful.
But doesn't the all government, I mean, how does that distinguish from other undercover investigations where the government is infiltrating and inducing someone to talk to the agent?
Well, I think that again, we're not making that specific argument in this case, but I think Wolf kind of opened the door a little bit here on this issue. In Wolf, the court considered whether the victim and her friend who spoke and listened to the defendant on speakerphone were instruments of the state. And this court considered the issue, whether the testimony of AO, who was the victim, and Tricia, who was a friend that was along with the victim, as to the contents of the conversation with Wolf, who was the defendant in that case, must be excluded as attributable to an unconstitutional privacy intrusion by a government actor. Those two individuals, AO and Tricia, AO in particular, merely spoke and listened to the defendant and did not record it. So under Wolf, it appears that you don't necessarily need to record a conversation with a defendant for it to be an unlawful search and seizure. So I think depending on the facts, you got to remember, you got to go back to the question. Each case is based on its own facts. Is there a subjective expectation of privacy on the part of the defendant? And whether society is willing to accept that as reasonable. And that doesn't necessarily require a warrant, I don't think, in every single case where there's an undercover agent.
Excuse me, Mr. Lubick, I want to talk to you about Wolf, and this comes back to the question I asked you earlier, is that Getz and progeny, and Wolf as well, are cases that involve government monitoring in some fashion of a conversation going on between the defendant and somebody else. That's not what we have here. What we have here is a communication between the defendant and another person who he doesn't know is a government agent. And I don't know that we have any case law that has ever even suggested that you have the right to an objective right to privacy, that the person that you're communicating with is not a government agent. Because that's the upshot of your argument, even though I know you're not making that argument. Can you respond to that?
Well, Getz, Allen, and Stewart, the expectation of privacy that was focused on there was not the informants. Looking back, Wolf probably does apply to the informants, but the expectation of privacy was a very narrow one in those cases. It was that the government wasn't monitoring and recording a private conversation between two individuals. This case, I think, is even more straightforward. This is a government agent speaking directly to Mr. Staker. That's the key fact here. We have government action from start to finish.
There's no question about that, but what's the significance of that in relation to your client's right to privacy?
So in Allen, this court acknowledged that the delegates had indicated, and this is coming from one of the committees, that all communications should enjoy protections from government intrusion. That is what I think is so key here. And I believe that Montanans have a reasonable expectation of privacy, that the text messages that they send to who they believe to be private citizens are in fact private citizens, not government agents who are electronically monitoring and recording those conversations. We have to have that basic confidence.
But I gotta stop you there.
So let me ask
Go ahead,
you
Mike.
this, similar vein. Allen, Schwartz, Getz, all or Stewart and Getz all were cases where the defendants in those cases knew who they were having a conversation with. And does it make any difference in this case that putting aside the inducement for a minute, that your client did not know who he was talking to? Doesn't that create, isn't that a distinction in terms of his reasonable expectation of privacy? I mean, he had no idea who he's talking to.
So I don't think it's necessarily true that in all three cases that the defendants knew the individuals they were speaking with. While the relationship in Getz, the majority opinion didn't go into great detail as to the relationship between the confidential informants and the defendants. The dissent argued that there was no reasonable expectation of privacy in that particular case between the defendants and the confidential informants, because they were engaging with strangers and non-confidants, engaging in a public and commercial-like drug enterprise. So implicitly, the stranger rationale was not adopted by this court. But as a practical matter, every person that we speak with the first time is a stranger. So you can imagine the breadth of conversations that would be excluded from the right to privacy if this court adopted a stranger rationale. It would examine first-time romantic inquiries, employment inquiries, and other types of lawful inquiries, regardless of their private nature. Society.
Well, but counsel, I think your arguments in your brief try to hinge it on that very thing. You argue that had Lily been actually a private citizen,
Yes.
as the defendant thought,
Mhm.
that it would be okay for police to take those messages from her without a warrant. So it comes down then, doesn't it, to just what a defendant really believes subjectively. That's, under your argument, that's what the right of privacy turns on.
Well, Justice Rice, what you're raising is in Getz, this court said that we're willing to take the risk that the person that we converse with will repeat that conversation, but we're talking about private citizens in that particular scenario. That's what the court was speaking to. But the court went on to say that you have a reasonable expectation of privacy, that the government itself is not monitoring and recording those conversations. So what I meant by in my brief is that, yes, Mr. Staker believed that Lily was a private citizen. So he didn't have a subjective expectation of privacy that she wouldn't tell this conversation to her friend or even the government. But Mr. Staker did have a reasonable expectation of privacy that he was not conversing with a government agent who was recording and communicating with him without his knowledge.
So counsel, doesn't that really beg the question of the qualitative difference between a text and an oral communication? And back to Justice Sandifer's point that, he put this recording in motion, Staker himself. And there's a difference between an oral communication and recording it, which makes it permanent and can be transferred to other and used as the text here.
Well, Your Honor, in this case, Agent Noe was a government agent from start to finish. He fabricated a citizen named Lily and solicited Montanans to contact Lily through an advertisement. Agent Noe obtained a recording device. A cell phone is a recording device, and he used it for the purposes of recording and responding to text messages. And that's what we under Getz.
Excuse me, Mr. Lubick.
Yes.
But you're avoiding the point,
Mhm.
is that the government didn't search any recording device. It didn't use a recording device to monitor anything here. What happened is this was a two-way communication, and your client on one end of it generated a record and transmitted it to this person who he didn't know was a government agent, but he nonetheless generated the record and sent it down the wire. And how can you say that the government is somehow monitoring a private conversation by analogy? I don't understand that.
I guess what I'm saying is that but for the agent obtaining the recording device and creating the inducement, there would not have been an electronic recording. It was Agent Noe who electronically recorded. We can't.
Counsel, but it wasn't electronically recorded. I mean, it was effectively self-recorded. I mean, I'm old enough to remember 2018, and text messages were already a thing by then. And I mean, your client was an adult sending text messages to someone he believed to be a sex worker. And you're acting like he's an Amish teenager on his first day of Rumspringa. I mean, he knew what he was doing. He was sending text messages out to an unknown person. I mean, it's not like this would be the first person who misrepresented themselves on the internet or electronically. I mean, I don't even see where we get past the subjective expectation of privacy here. Who you're communicating with is A, who he or she says they are, and B, that they're not going to share the communications.
Well, this court has stated that Article 2, Section 11 extends to all Montana citizens, including those suspected of a criminal act or charged with one. And as to the reasonable expectations of privacy, this court has said we must remember in making this determination. Look, we all use cell phones. One of the points I've been trying to make about this is the ubiquitous nature of cell phone communication. And we've kind of skipped over that, but It helps me explain the policy behind why I think this is important. It's important because public norms and communication are rapidly evolving.
But that's kind of the point, isn't it? I mean, when my kids got their first cell phone, they were told, remember, anything you put out there on texts or pictures or whatever, you should expect that it's going to be shared. And I mean, it's like, it seems to me that because electronic communications have supplanted oral communications to an alarming degree, it seems that you're wanting us to hold your client to a lower standard than we would hold a middle school student who knows that their texts are going to be shared.
Well, Your Honor, I mean, anything that we say to anyone, it can be shared. I mean, we often tell our children you shouldn't say certain things to certain people as well. So I think it's analogous in that manner. But you know, this court in Allen, one of the things that this court looked at in Allen was that cell phones were ubiquitous in Montana as elsewhere. And the court looked at the vital role that cell phones play in private communications in deciding that case. That was a part of that. Well, text messaging plays a vital role in our private communications as well. The US Supreme Court, as recently stated, was in the Kwan case, cell phone and text message communications are so pervasive that some persons may consider them to be essential means or necessary instruments for self-expression, or even self-identification. We can't help the fact that when I send a text message to somebody, that somebody receives that same text message on the other side, but that is how we communicate. It's been said that we text more than we talk, and I cited a bunch of surveys in my brief that talks about it, that we are texting more than we talk. And so we're making
excuse me, but so to that point, if this was an in-person communication between your client, and it wouldn't have been the agent in this case, because he probably would have figured that the agent wasn't Lily since he was a guy, but if it was an in-person communication, would there be anything, or if, as Justice Sandifer alluded to, he wrote Lily a note, I mean, would there have been anything, what would your argument be then? I mean, this is the way they communicate now.
Well, I think if there's an inducement on the part of the government to obtain the defendant's written or oral thoughts, then that is a search. I'm not sure if I answered your question.
Well,
Oh,
no,
yeah,
I mean,
you answered mine. I was going to ask you that very question.
Yeah, I mean, I guess my thing is it's like the state alluded to. I mean, we're talking about an undercover operation here. And in previous years, there might have been a police officer posing as a sex worker, and the conversations between the two. And if that, say, was somebody who was just standing out in an area where there was known sex work, then, I mean, that's basically the same as advertising on the internet now. I mean, whereas, I get you're saying there was an inducement because there was an ad, but every advertisement, I guess you could call an inducement. Nobody forced him to initiate this text. It wasn't directed specifically at him.
No, but then we have to be wary of any type of advertisement that we respond to via text. I get text messages from all sorts of people that I don't know. I don't expect them to be government agents, and I would hope that they wouldn't be. I think that Wolf does change the dynamics. I don't want to argue that. My argument is that he was electronically monitored and recorded unlawfully, but there is a question as to other types of undercover investigations. But I just go back to, this case is unique, so is Getz. It was based on its facts. You have to have a subjective expectation of privacy, and maybe the sex worker on the street, given that the particular scenario, didn't have a subjective expectation of privacy in that conversation. And based on who was around or what was going on, it wouldn't have been objectively reasonable. But what I'm saying is that this is how we communicate. The Article 2, Section 10, I don't believe it dictates the type of conversations that we have as to what it's going to protect. I don't think we should be analyzing it from the perspective that, well, we'll go as far as oral face-to-face conversations. Well, let's extend it to cell phones because they're ubiquitous and that's how people communicate now. But now we're text messaging. That's how we communicate. And so if this court were to hold that text messages aren't protected by Article 2, Section 10, there's a lot of conversations out there that are just not going to be protected. In
But
fact,
isn't there a difference between having, and I think your point would be well taken, if the government had searched Mr. Staker's cell phone. I mean, he put these text messages out there, and the text messages were received by the government, somebody who he believed to be a sex worker. I mean, I think that there's a big difference between the government searching somebody's cell phone or the government intercepting text messages between two private individuals versus someone who, if Lily was an actual sex worker and she surrendered her phone, what would the argument be there?
Yeah, I'm not exactly sure of those particular facts. I mean, those aren't the facts that we have before us. I mean, there could be it's an interesting question for sure, but I'm not sure that I can answer that today. I think that's a.
Well, Mr. Lubeck, that's actually the state's argument is a third party situation where, I mean, if you have a text between two friends, and maybe one of those people isn't such a great friend and turns the text over to law enforcement, how is that different than here?
Well, and the court addressed that in Getz. It said that that's perfectly okay. That Lily, as a private individual, can share the conversation that you have with her with others. And I think that includes the government. In fact, that happened in State versus Wolf, and that wasn't even argued or raised, but the agent in that case was looking at the text messages. The issue is the government being directly involved in this particular case. Let me just give an example to the court. To allow law enforcement to use text messages in the manners used in this case would give them incredible unrestrained powers. I mean, imagine dating sites. Law enforcement could develop a Lily profile, solicitation on a dating site, and the agent involved could develop fake relationships with people, and just to see what they're up to, and then engage in conversations, and based on those conversations, find out criminal information about them or others, and then charge them criminally. It will allow them to impersonate people that we know, become our friends on Facebook, and I think the right to privacy protects us from that type of intrusion.
Mr. Lubeck, though, the government has been impersonating people who are not government agents since the dawn of law enforcement. That's the whole point of undercover work. And whether it's a electronic medium as the medium of communication, it's the spoken word, or it's some paper and pen, that's just a medium of conversation. And so the issue has to be, as far as an objective expectation of privacy, what the totality of the circumstances are. And I just can't get past this, as you keep saying that your argument isn't that you have some expectation of privacy, that you're not talking to a government agent, but then it seems that is all your argument boils down to, is that the government, your guy didn't know that this was a government agent.
He didn't know that he's going to be electronically monitored and recorded by a government agent.
But I can't let you get away with that. Your client made the record and sent it down the wire. The government didn't record anything. Your client generated the record on his cell phone and then hit the send button, and down it went.
I understand that, Your Honor, and we just have I guess a fundamental disagreement on that, because Agent Noe obtained a cell phone for the purposes of recording those conversations. He knew that people were going to respond, and he was going to be able to record it. And under Getz, you can't do that without a warrant. If this might be a good time to allow amicus to argue its point, or if the court
That's
had other
fine.
questions.
It's fine.
Good morning. May it please.
There you go.
Thank you, Mr. Chief Justice. Good morning, Justices of the Supreme Court. Just Colin Stevens on behalf of the Montana Association of Criminal Defense Lawyers. I want to argue very briefly about the issue that was posed in our brief on anticipatory warrants. I think it provides a nice answer to some of the questions that have been posed today. For example, Justice McKinnon, your question as to inducement and entrapment, and to some extent, Justice Sandford's questions about traditional law enforcement activities in a sting. What happened in this case wasn't a traditional sting. It was what normally would be referred to in federal law as a reverse sting, where law enforcement actually initiates the criminal activity. So in that case, where law enforcement is the impetus behind the criminal activity, sort of the Matahari to draw the criminals in, there's no reason in that case that law enforcement doesn't have the time to obtain a search warrant. And in that case, the anticipatory warrant is the perfect tool to fit the concerns of this case. It's a warrant that goes to an issuing magistrate that says, Your Honor, we have probable cause to show that at a future date, a triggering event will occur that suggests that probable cause is that there will be evidence of a crime at this location. So in this particular case, nothing prevented Agent Noe from getting the cell phone number, placing the ad, going to a magistrate or a judge or a justice of the peace, and doing exactly what happened in Missoula that is attached to the appendix at our brief.
Excuse me, Mr. Stevens. Certainly law enforcement could do that, but the fact that law enforcement can get a warrant doesn't determine whether or not the other individual has an objectively reasonable expectation of privacy under the circumstances. That's not the measure or standard or threshold for determining whether there's an expectation of privacy. The fact that they could have got a warrant doesn't matter.
I don't disagree with that, Justice Sandford, and I understand that the argument that amicus is making is entirely predicated on this court resolving the bigger question that a warrant is required in the first place. And so, Justice Baker, you had asked again about undercover investigation. And one of the distinctions that I really want to draw in this case, before I reserve time for Mr. Lubeck to answer Justice McKinnon's statutory construction question, is you have a traditional sting on one hand where there may or may not be a warrant required. Here in the reverse sting, you create a situation where individuals approach it with an expectation of privacy. And I think that it's absolutely subjective, and it's objectively reasonable that any number of situations where a reverse sting occurs. And I would say, just in response to Justice McKinnon's reference to 45.5112, that this is, I think what happened here is you had an agent who went to the Verizon store and obtained a cell phone for a very specific purpose. And I'm not entirely sure that that situation is covered by sort of the traditional government data that's referenced in this statute. The court's obviously free to correct me on that, as is the legislature, but I think that's the issue. And so I guess, again, just to prevent some of the slippery slope arguments, amicus proposes that there is a reasonable expectation of privacy, that an anticipatory warrant is a tool that law enforcement can have to obtain a search warrant and to conduct a reasonable, constitutionally permissible reverse sting in situations that happened in this particular case. If the court has no further questions, I'll reserve the rest of Mr. Lubeck's time.
Thank you, Mr. Stevens.
Thank you.
Ms. Ployar.
Morning. May it please the court. My name is Mardell Ployhar. I'm an assistant attorney general representing the state of Montana. Travis Staker did not have a reasonable expectation of privacy in text messages that he voluntarily sent in response to an online advertisement for prostitution. This court should affirm the district court's denial of Staker's motion to suppress and dismiss for 3 reasons. First, this court's precedent in Getz, Allen, and Stewart does not require suppression of the text message conversation. Second, this court's recent holding in Wolf is limited and does not stand for the proposition that Staker has argued it stands for. And third, this court should not expand its prior precedent to make a text message conversation a search. This court has followed federal precedent holding that a person does not have a reasonable expectation that what he says to another person will not be repeated. Under the Fourth Amendment, a person does not have a reasonable expectation of privacy in a message that he writes and sends to another person if that person chooses to disclose the message to others. A person also does not have a reasonable expectation that the person with whom he is communicating is not deceiving him about his identity or the purpose of the conversation. This court has applied that same rule under the Montana Constitution when interpreting the right to privacy. In Allen, this court held that an informant who was acting as a government agent in that case could testify about her conversation with the defendant, even though the recording of that conversation was not admissible. Similarly, in Stewart, this court stated that whatever expectation of privacy Stewart may have had in his conversation with his daughter, it could not include, for purposes of Allen, the expectation that the conversation would be kept secret and never repeated. Instead, the expectation of privacy under Allen is that the government is not monitoring the conversation and making recordings of them. If a person chooses to send a text message, which by its very nature creates a recording of the message in the recipient's phone, that person does not have a reasonable expectation that the messages will be kept secret and never repeated. As one of the justices already noted, a text message is similar for constitutional purposes. It is similar to a letter that has been sent. Once it is received by the recipient, the sender no longer has control over whether that letter is disclosed.
So Ms. Ployhart, what if, I mean, you know, like we've done now with email communications because we mess up when we send them and whatnot. So what if we put at the bottom of the text messages, private, do not disseminate? Like, does that change your, I mean, is that what we're going to need to do now to have an expectation of privacy, or what do you think about that?
I don't think that would change the outcome because the sender still does not have any control over what the recipient actually does with it.
But his expectation of privacy at least would be set forth. Like, I think I'm having a private conversation with you and I think you're not a government official, you know, and I think this should be kept private. You don't think that changes it at all?
I think that sets forth what the sender would like, but I don't think that actually changes what he has any right to put.
So Ms. Ployhar, would that be?
But go ahead, Lori.
Well, just, isn't that more of a question of whether it's a expectation of privacy that society's willing to protect in light of the idea that the letter can go, that the sender loses control over the outcome of whatever that information is?
Yes, Your Honor, yes. Even if such a statement could change somebody's subjective expectation, it cannot change what society is considers to be a reasonable expectation of privacy. And part of the defendant's argument, of course, is based on this idea that there was somehow something improper about an undercover investigation. And that is not supported by this court's case law. This court held back in 1978 in State versus Leidy that an undercover investigation did not violate the defendant's right to privacy. And since then, this court has never suggested that an undercover investigation constitutes a search unless the investigation involves the surreptitious electronic monitoring and recording of an oral conversation, which occurred in Getz and Allen and Stewart. But even in those cases, the government used an informant or the victim in the case as a government agent to obtain information from the defendant. This court never suggested that that practice was improper. And this court held in Allen and Stewart that the government agent could testify about the conversation, even though the conversation was recorded in violation of the defendant's right to privacy. That is because there was nothing illegal about the act of using a government agent in the investigation. This court's
Ms.
holding.
Playhart, can you address its combination of the defendants and the amicus argument that in this case, the undercover, the lawfulness or the lack of a privacy invasion has to be viewed from the standpoint of a reverse sting, that it's not the traditional undercover where the government infiltrates an existing criminal operation, but the government is the impetus for the criminal operation. Does that change anything in your argument?
It doesn't change anything with regard to the right to privacy. You know, the same two factors are still the same factors as far as the expectation of privacy in a text message that was sent and whether society would consider that to be objectively reasonable. You know, certainly there is entrapment as a defense, the facts, and I think that that's kind of what is being suggested, but that the defense was not raised, and it's reasonable that it wasn't raised because this in no way constitutes entrapment. You know, simply posting an advertisement on the internet, the defendant chose to send a written message to that phone number, you know, post it on the internet, and all that law enforcement did was to post that advertisement. That certainly, you know, is not entrapment, and that action does not change the right to privacy. I would like to address the Wolf decision because, of course, it came out after I filed my brief, so I wasn't able to address it in my briefing. And I disagree with I do not believe it stands for the proposition that the defendant had used it for. Of course, in that case, a rape victim answered her cell phone using the speakerphone when the defendant called her, which allowed her friend and law enforcement to overhear the conversation. And the district court in that case allowed the victim in the case and her friend to testify about the contents of the conversation. This court held, and the only thing that this court held in Wolf was that because they were private citizens, their actions did not implicate Wolf's constitutional rights. This court addressed whether they were government agents and concluded that under the facts of Wolf, they were not government agents. They were acting on their own behalf. But it's very important to look at what this court did not hold in Wolf. This court did not hold that if they had been government agents, their testimony would have been inadmissible. So nothing in Wolf did anything to change this court's prior holding. To the contrary, this court noted in footnote 2 of Wolf that regardless of whether they were government agents, Wolf had no reasonable expectation of privacy that the victim would not repeat what he told her. This court noted that it was not necessary to decide whether Wolf had a reasonable expectation of privacy that the victim's friend would not be listening to the phone conversation. So this court did not decide whether the victim's friend would have been able to testify if she were a government agent. Wolf therefore did not hold, as Staker has asserted that held, that a person has a reasonable expectation of privacy that the individuals with whom they converse are not acting as a government agent, but is actually contrary to what this court held explained in footnote 2 of Wolf. Instead, Wolf reaffirms what this court previously held in Getz and Allen and Stewart, which is that a person does not have a reasonable expectation of privacy in statements that they make to another person. And that is true even if that person is acting as a government agent. The only thing that was excluded by this court, the only thing that this court held was a search in Getz and Allen and Stewart was the surreptitious electronic monitoring and recording. And of course, that is fundamentally different than what occurred here, where Staker knew that he was sending written messages to the phone number that he found online. He found this phone number and sent written messages that were going to be stored in the phone of the recipient. I'd also like to address, Staker has attempted to distinguish between the private citizens who are acting as informants in Getz and Allen and Stewart, to distinguish between them and law enforcement, the salaried law enforcement officers that were acting in this case. And that distinction is not correct, because the issue is simply whether a person is acting as a government agent. If somebody is acting as an informant on behalf of the government and they're cooperating with the government, they are a government agent. And that is not, the fact that there were salaried law enforcement officers in this case is not a reason to distinguish this case from Getz and Allen and Stewart, where particularly in Allen and Stewart, this court held that those government agents could still testify about their conversation with the defendant, even though they obtained the statements while acting on behalf of law enforcement. This court should reject Staker's invitation to significantly alter Montana law by prohibiting undercover investigations that are conducted without a warrant. In Montana and elsewhere in the United States, undercover investigations have been routinely approved of to enable law enforcement to gather evidence, solve crimes, and to prevent future offenses. In Lewis, the United States Supreme Court stated that the government is entitled to hide the identity of agents, and that is consistent with what this court held in State versus Relied. The United States Supreme Court stated in Lewis that to prohibit undercover investigations would severely hamper the government in ferreting out those organized criminal activities that are characterized by covert dealings with victims who either cannot or do not protest. And human trafficking is a prime example of one of those types of offenses. In order to be able to investigate and limit human trafficking, law enforcement needs to be able to conduct undercover investigation. Excuse me. In this case, law enforcement posted advertisements in several online forums to catch individuals who were hiring prostitutes. They did that not just because prostitutes are themselves engaging in illegal activity. More importantly, prostitutes are often the victims of human trafficking. Arresting the men who hire prostitutes and the publicity surrounding those arrests allows law enforcement to reduce the demand for prostitution, thereby reducing human trafficking. This is an important investigative tool that law enforcement needs to be able to conduct.
Counsel, what about Mr. Lubeck's argument that would this open the door for government agents just going on dating sites and striking up conversations and eliciting, or not even necessarily eliciting, but in the course of those conversations, learning of if somebody might have inclinations towards some criminal activity that is wholly unrelated to human trafficking?
Well, under current law enforcement is not limited in their ability to do that, but they are limited. They do not do that because of their judgment and also limited resources. There's no reason to believe law enforcement is going to be just searching around the internet without any reason to do so. Of course, that is very different than what happened here, where law enforcement posted this advertisement and Mr. Staker reached out to law enforcement. They had no idea who was going to reach out to them. So that is completely different than the circumstances of this case. And when we're looking at Mr. Staker's right to privacy, he did not have one in this situation. If there is if that sort of situation ever comes up under those facts where somebody, law enforcement was searching with absolutely no reason, that person could possibly raise some claim under Article 2, Section 10, arguing that there was not a compelling state interest, which is what is required under Article 2, Section 10, of course, a compelling state interest. So maybe in that circumstances, it would be a very different circumstance if that person were going to raise some sort of privacy. But Mr. Staker, of course, is the person who reached out to law enforcement. There's no reason to fear that the law enforcement was out trying to search for Mr. Staker. When Mr. Staker responded to the advertisement for an illegal sexual service by sending a text message, he had to have known that the recipient would have a copy of that message in a written record of that message in their phone. He also reasonably should have known that he could have been talking to a prostitute, or he could have been communicating with a human trafficker who sets up an encounter for a prostitute, or he could have been communicating with an undercover officer. Under those circumstances, he did not have a reasonable expectation of privacy when he sent a written message in response to a phone number that he found on the internet, and he had no idea who the person was on the other end of the line. The anticipatory warrant that is proposed by the amicus should not be required before law enforcement engages in an investigation like the one in this case for two reasons. The most important reason, number one, of course, is that no search occurred. A warrant is not necessary where a search has not occurred. Second of all, an anticipatory warrant is not designed for the process like for the situation like occurred in this case. An anticipatory warrant was approved of by the United States Supreme Court in United States versus Grubbs. In that situation, the defendant had ordered a recording of child pornography, and law enforcement knew that it was on its way to the house and was going to be delivered. And they obtained a search warrant so that after the recording was delivered, law enforcement would be able to enter the house to seize the evidence. But in this case, law enforcement, all they did was to post an advertisement. They did not know who was going to respond to the advertisement. They did not have probable cause about any specific individual. And to require a warrant in that situation does not serve the purpose of a warrant, which is to have a neutral judge review the facts of the case and to determine whether they're facts demonstrating probable cause that an individual has committed an offense and that evidence can be seized by conducting a search. That is not what we have here. We just have law enforcement posting an advertisement, and which brings me back to, most importantly, that is not a search. When all that is conducted is an advertisement is posted and law enforcement simply received the messages that Staker sent to them. This is not a situation where law enforcement was searching through Mr. Staker's phone or obtained any other evidence. The only thing that law enforcement obtained were the text message written communications that Mr. Staker chose to send to law enforcement. The Rhode Island Supreme Court explained well the nature of a text message in State versus Patino when they explained that a person did not have a reasonable expectation of privacy in text messages. The court stated, "We can think of no media more susceptible to sharing or dissemination than a digital message, such as a text message or email, which vests in the recipient a digital copy of the message that can be forwarded to or shared with others at the mere click of a button." And that is what occurred in this case. Mr. Staker chose to send a written message to law enforcement, leaving that message in the control of the recipient. And at that point, he did not have any reasonable expectation of privacy in that. The state's position, of course, is that a person does not have a reasonable expectation of privacy in any written message that they have sent to another person, but also if this court is not willing to adopt that broad ruling under the facts of this case, these circumstances demonstrate that Staker did not have a reasonable expectation of privacy because, as I mentioned, he was simply responding to a phone number on the internet under a posting for illegal sexual services. In that circumstances, he did not have any expectation that the message that he sent would be private.
Counsel, you're not suggesting though, are you, that if this had been Mr. Staker text messaging his brother or his parents, that he wouldn't have a reasonable expectation of privacy, that it could have been intercepted by law enforcement, are you?
Definitely not, Your Honor. No, law enforcement, that would be a very different situation, of course, if law enforcement were trying to intercept a message. You know, if somebody is sending a message to their brother, their mother, they don't have a constitutional right to privacy. They just have a reasonable expectation. I think that their family members aren't going to turn their message over to law enforcement, but
Some family members.
certainly that can happen. Yes, that can happen. I believe the King case, United States versus King, I believe it was the Sixth Circuit case that I cited, is the case about a letter, how a person doesn't have a reasonable expectation of privacy in a letter. And I believe it was the person's spouse that turned the letter over to law enforcement. So that certainly can happen.
Counsel, can you address the statute that I,
Yes, thank you, Your Honor, for the reminder. Yes, the statute, I think the statute does help to support the state's position sorry, I'm reviewing it again. As it notes, law enforcement, the statute that requires warrants for obtaining, and I think this statute, it looks like it's fairly recent. It probably was passed to be, consistent, I believe, with Riley, I might be mispronouncing the case, but law enforcement can't just do a search of somebody's phone without a warrant. But of course, it notes in the section you stated that does not limit law enforcement's ability to use any information contained on their phone. And what occurred here, of course, is that Mr. Staker sent the message to this phone number, and it was a law enforcement phone number. There is nothing wrong with law enforcement using that message that was sent to them. And that is very different, of course, in the situation, as Justice Shea, the situation he suggested, where law enforcement would be trying to intercept information from somebody's phone.
well, and I guess my concern is it seems to address this situation, and I don't quite know how it fits into the cases in this court's precedent. So thank you. I do have a question though. Doesn't that also imply that a government's wire on an informant, that's the wire is the electronic device of the government? And so how do you get around our case law that says that's prohibited absent a warrant?
Well, of course, the Constitution is going to trump anything in a statute. And I don't know when this statute was drafted, I don't know that anybody was thinking of that interpretation where the government owns the wire. I don't believe that. I believe the statute was passed, vague recollection of
2007, 2017.
Right. But my understanding, and this is without reviewing legislation, was that this was passed in order to be consistent, enhance privacy. I don't think it was trying to undo the Gatz et al. Decision.
Okay.
I think it was probably thinking more of cell phones. And don't know what year the United States Supreme Court issued United States versus, sorry, I think it was Riley. I might be mixing up my case names, but of course the United States Supreme Court did hold that the government cannot search a phone if they seize it as a search incident for arrest. And the state is not in any way disputing that, the government would not have been able to search through Mr. Staker's phone without a search warrant. But of course, what occurred here is completely different, where Staker sent the messages to the phone number and law enforcement simply received them into their phone. And nothing in the statute or Constitution would prevent law enforcement from using those messages that they received.
Okay.
Court has no further questions. The state will ask this court to affirm the district court's denial of Staker's motion to suppress and dismiss. Thank you.
Thank you, Ms. Ployhar. Mr. Lubeck, do you have rebuttal?
Yes, Your Honor, thank you. First I wanted just to address the statute 465112.
Sorry, I'm sorry to interrupt, but I think the clock hasn't been reset yet for the rebuttal.
I think it's.
It's good to go with the rebuttal time.
May I proceed?
Go ahead. Yes, go ahead.
Your Honor, I don't see how it applies to this particular case. It provides that you need to have probable cause, and it has a series of exceptions. The consent of the owner is one, exceptions to the warrant requirement, voluntarily and publicly disclosing the stored data, I mean, the argument might be that he did that in this particular case, but it wasn't publicly. This was between two individuals. This was between him and Lily. Talks about good faith belief that there's an emergency. I'm shorthanding here because of the limited time. Responding to a user's emergency call or found within an adult or youth correction facility. I just don't see how any of those particular exceptions apply.
I'm referring to subsection 3, which specifically says that the government's own electronic device is an exception to the warrant requirement.
I see what you're saying.
But that's okay. You don't have to spend your time on that.
Okay. I would argue that Article 2, Section 10 would trump that, along with Article 2, Section 11. Wolf was brought up, and well, actually, let me just talk about the dating site, because I think that really is Pandora's box here. I think it's indistinguishable what we're talking about here. The state said, was asked about that, and I don't want to get it wrong and rely on your own memories, but I understood her to say that law enforcement wouldn't look at these because of judgment and limited resources. And that a defendant could possibly raise some sort of issue, some sort of constitutional issue, but that's a very different set of circumstances. And I just don't see how that is. This court has stated and gets, nor should the underlying purpose or content of the conversation at issue reflect upon society's willingness to accept a subjective expectation of privacy in those conversations as reasonable. So we don't look at the content or even the purpose. So the state's trying to say, well, that Mr. Staker is involved in criminal activity, and so that should make a difference. It doesn't make a difference in this court's case law. And there's no difference between Mr. Staker responding to an advertisement for alleged prostitution services versus a person who's responding to a romantic inquiry on Match.com. They're both the same under the case law. We don't look at the purpose and we don't look at the content. And so this really is, I think, Pandora's box, where the law enforcement would have free reign to do basically whatever they want to do if it's in text.
Counsel, what about, I wanted to kind of go back specifically as it pertains to the communications that happened here. Is you made a comment that Mr. Staker had a reasonable expectation that Lily was who she said she was, that she wasn't law enforcement. Even in the communications that they had, and I think this was the initial exchange, he asks her, says, "I'm sure you get this all the time. Sorry in advance. Are those your real pictures?" So, I mean, even subjectively, he wasn't assuming that she was who she said she was. I'm sure he didn't think she was some dude named Rodney, but he didn't think that she was, or he at least had his subjective skepticism that she was who she said she was.
Right. I mean, I don't think that he had a subjective expectation of privacy that's what she looked like necessarily. And he was making an inquiry like we all would of people. What I would say about that is that, I mean, he showed up. He had an expectation. The fact that he went through with this shows that he had a subjective expectation of privacy, that Lily was Lily and not a government agent.
But I mean, it's possible that the Nigerian prince who wants access to my bank account information is really a Nigerian prince. But these conversations, I mean, we're living in an era where we all, I think, reasonably have a healthy dose of skepticism that strangers on the internet and or that we're communicating with that was initiated on the internet aren't who they say they are, don't we?
Yeah, I mean, but we have the same concerns when people call us on the phone. People
Right.
call and say that you have an overdue bill, or I'm trying to think of the analogy that I always get, that you're late on your mortgage, or you didn't file taxes. I mean, all these things can be done in any kind of medium. And so, yeah, I think we're skeptical. I think the right to privacy is what protects us from the belief that government agents are out there surreptitiously looking at our text messages, monitoring and recording these text messages.
But that is the difference that I asked Ms. Ployar. I mean, this wasn't something where text messages were intercepted. or that they even searched Mr. Staker's phone. These were text messages that he put out there, as Justice Sandifer alluded to. He generated them, and he sent them off to a cell phone that was owned by a law enforcement agent. I mean, isn't that a really big distinction?
But we all do that. I mean, at least I've done that. I've taken that leap of faith and sent text messages to somebody who sent a text message to me that I did not know. Am I to assume that that's a government agent?
Well, the question would be, does society think that's a reasonable expectation? But in any event, your time has expired. Thank you to both counsel. And also want to take this opportunity to thank the University Law School for the introductory presentation. It was very good. I'm sure it was helpful. And thank you for participating in this Law Day event, even if it is remotely done. Thank you very much. We will take this matter under advisement and issue an opinion in due course.